Legal basis of international relations.
There are two doctrines of adoption. First, doctrine of incorporation. The doctrine of incorporation is mainly based under Section 2, Article 11 of the 1987 Constitution, which states that XXX, the Philippines adopts generally accepted principles of international laws as part of the law of the land. Thus, the generally accepted principles of international law are considered as part of the state's national laws by reason of its membership in the family of nations.
2. Doctrine of transformation. The doctrines of transformation requires the enactment by the legislative body of such international law W principles as are sought to be part of municipal law, Cauquia and Defensor Santiago, 2005. This doctrine must be related to the power of the President to enter into treaties wherein rule and principles embodied in said treaties would be transformed into Philippines law and would become valid and effective upon the concurrence of 2/3 of all the members of the Senate, Section 21, Article 7, 1987 Constitution. International Convention and International Customs. International Convention. International Convention are international agreements concluded between states in written form and governed by international law, embodied either in a single instrument or in two or more related instruments, and whatever its particular designation. Article 21A, Vienna Convention on Law of Treaties. Samples of bilateral treaties entered into by the Philippines are the Mutual Defense Treaty with USA, signed on August 30, 1959. The RP-US Extradition Treaty with USA, signed on November 13, 1995. At time, the Philippines also enter into multilateral or conventions with two or more states, an example of which is the 1982 United Nations Convention on the Law of the Sun, UNCLOS. Other examples are the International Convention on Civil and Political Rights, Rome State International Criminal Court, and Convention on the Prevention and Punishments of the Crime of Genocide. International customs, also known as customary law, consists of rules of law derived from the consistent conduct of states, acting out of the belief that the law required them to act that way. However, of a custom to be deemed as an international custom, these text elements must exist. State practice in opinio juris sive necessities. State practice states that there must be evidence of substantial uniformity of practice by a substantial number of states. August 2010. In a leading case rendered by the International Court of Justice, the case of North Sea continental shelf cases. Proof of state practice are as follows: administrative acts, legislation, courts decisions, historical records, international stage activities. Opinio juris sive necessity states the belief that the given practice is rendered obligatory by the existence of a rule requiring it. Consequently, the states concerned must feel that they are conforming to what amounts to a legal obligation. Kinds of international customs are regional customs and special or local custom. Regional custom. Regional custom is a practice among states within a particular area of the world which can be sufficiently well established and accepted as law as is binding among the states of the region but not elsewhere. A special custom, on the other hand, is a long-continued practice between two states, accepted by them as regulating their relations, that form the basis of mutual rights and obligations.
Jus cogens and obligations erga omnes. Jus cogens occupy another category of international customs, as these refer to norms that command peremptory authority, superseding conflicting treaties and customs which can neither be derogated nor modified, except by a norm or similar character. Jus cogens enjoy a higher rank in the international hierarchy than treaty law and even ordinary customary rules. Example of this are norms on torture, racial discrimination, genocide, and piracy.
Obligation erga omnes refers to an obligation under general international law that a state owes in any given case to the international community in view of its common values and its concern to compliance, so that a breach of that obligation enables take action, or an obligation under a multilateral treaty that a state party to the treaty owes in any given case to all the other states parties to the same treaty in view of their common values, so that the breach of the obligation enables to all that states to take action. Example of this are prohibition of acts of aggression, on genocide, and on the protection of basic human rights.
Basic principles concerning treaties. A treaty binds the parties and only the parties. Agreements must be kept. Every treaty in force is binding upon the parties. It must be performed by them in good faith.
A fundamental change of circumstances which is occurred with regard to those existing at the time of the conclusion of a treaty, in which was not foreseen by the parties, may be involved as a ground for terminating or withdrawing from the treaty, if the existence for these circumstances
Contributed an essential basis of the content of the parties to be bound by the treaty, and the effect of the change is radically to transform the extent of the obligators still to be performed under the treaty.